Hello friends, welcome to Insights on Issues. Myself Nikhil K. Gowda, insightias, political science, polity and IR faculty. Today I am going to take up an important issue that is related to bail. We have seen in recent times the arrest of Delhi CM Kejriwal, BRS MLC K. Kavita, Manish Sisodia. All these issues are related to bail, which can be an important topic in UPSC. Now let's first get into the issue to understand what has happened, then we'll go into discussing about bail. Arvind Kejriwal, the Delhi Chief Minister then, he was arrested by Enforcement Directorate for a policy change which his government had brought, Delhi liquor case. So the Aam Aadmi Party, which was in power in Delhi, had brought a policy change where they had allowed the private players now to enter the liquor business, and there was allegations against the government that there was corruption, kickbacks that was taken by the party, and it was used for funding their elections in Punjab as well as Goa. Similarly, the BRS MLC K. Kavita, she was accused that she was involved in transactions where she had received 100 crores in that regard to fund the Aam Aadmi Party for the Goa elections. So the ED had made arrests Arvind Kejriwal, K. Kavita, Manish Sisodia. Now this becomes important to understand how bail works in Indian jurisprudence. In the case of Arvind Kejriwal, recently the Supreme Court granted bail. Even prior to that, Mr. Kejriwal during the time of Lok Sabha elections had received interim bail. So interim bail refers to a short-term bail where a person can go out of prison for a short duration and come back. But now Mr. Kejriwal has received a regular bail because this court felt that there was no reason that Mr. Kejriwal will misuse his powers to influence the case. But however, there are certain conditions that has been imposed on Mr. Kejriwal. So one is that he cannot regularly visit the CM's office. Second one, he cannot take major decisions unless it is required by the Lieutenant Governor to ask the CM. But anyway, today Kejriwal has resigned from the CM and Atishi has taken over it. And third one, Mr. Kejriwal should not make any public statements regarding the particular case. And fourth one, he should not meet any key witness. So these have been the conditions that has been imposed by the court. Secondly, in K. Kavita's case, where we can say she was arrested by ED under Prevention of Money Laundering Act, PMLA, which is famously called as. So in this particular act, there is a particular section called as Section 45 Clause 1. So in general, Prevention of Money Laundering Act, where we say bail is not the rule, but it is an exception. So what do I mean? Bail is not a rule, but it's an exception. It's very, very difficult to get bail in these cases unless there is strong reasoning to it. Now, it is argued by Kavita's lawyer that Section 45 Clause 1 allows bail especially for women, those who are sick or those who are children who are aged below 16. So in this regard, they demanded bail for K. Kavita. And here also, in case of PMLA, the accused will have to prove to the court that why they deserve bail. One, they'll have to show that there is no prima facie evidence against them. Second, they'll have to also prove to the court that there will be no way going to be a harm if they are out on bail, which is going to impact the case. So in this regard, ED had opposed giving bail to K. Kavita, saying that she is a minister or she is a politician, she is influential and she might harm the case. But however, the Supreme Court said that we cannot bring any kind of distinction between a common woman and MLC, hence they disregarded the ED's argument. Kavita's lawyer had argued that in previously the Delhi High Court had given bail to Preeti Chandra, the wife of Sanjay Chandra, in the Prevention of Money Laundering Act. Hence in this case also the same does apply. But however, the ED had objected, saying that we can't compare Preeti Chandra with K. Kavita because Preeti Chandra was a household woman and K. Kavita is an MLC and she is more powerful. But however, the Supreme Court took an interpretation here saying that nowhere in the constitution or nowhere under the Prevention of Money Laundering Act there is any kind of distinction or subcategorization of women that can be brought. Hence they said the ED's argument does not hold good and hence K. Kavita was granted bail. Third related issue which has happened recently, that is regarding to the SC/ST Prevention of Atrocities Act 1989. Here it is related to anticipatory bail. So for this, to quickly recap in that regard, previously the Supreme Court in the Subhash Kashinath versus State of Maharashtra case had given a verdict saying that anticipatory bail can be given in the case of SC/ST atrocities. Secondly, they had also told any kind of FIR have to be registered only after an enquiry has been done by SSP, that is the Senior Superintendent of Police. But however, there was a huge backlash saying that it might weaken the effectiveness of the SC/ST Atrocities Act. The Parliament had added a subsection 18 clause A, where they had said that they removed that there was no need of enquiry by SSP and an FIR has to be registered when the case is filed. In simple sense, the government or the Parliament made it status quo. Now, however, the Supreme Court, where there was a petition filed challenging the section 18A, the Supreme Court rejected the petition, but however the Supreme Court said anticipatory bail can be given if there is no prima facie evidence in case of SC/ST Atrocities Act. So friends, these were different issues that were related to the bails which has happened in the span of last 1 year. Now to summarize all these things in that, let's know about what is a bail and what are the different types of bail. The word bail is mentioned under the CRPC section, but it has been not defined there. So we can look at what are the different types of bails which are there. One, we have regular bail, which comes under CRPC section 437. Then we have anticipatory bail, which comes under CRPC section 438, which is usually given in cases where a person is anticipating his arrest in that regard. Before that, he can take a bail. Third, we have interim bail. Interim bail refers to what? Where a person who has been in judicial custody is allowed to move out for a short duration of time and to come back to the custody after the time that has been allotted by the court ends. Fourth type of bail what we have is the medical bail, which is given on medical grounds. And lastly, we have the statutory bail, the fifth type of bail. This is usually given under the CRPC section 167, where a person who is in judicial custody or police custody for 60 to 90 days and where the police have failed to complete the investigation and file the charge sheet is entitled to get bail. So these are the different types of bail: regular bail, interim bail, medical bail, anticipatory bail, and you have largely the statutory bail. Friends, I hope this video helped you in understanding what is a bail and how the mechanism of bail works in Indian judicial system. With this, I am signing off. I'll meet you again with a new issue and next week. Till then, take care, stay safe.